did mention
No donuts today, buddy.
racking.
Oh, the re-racking.
Yes.
That is correct, yes.
Now, this is your, this is right. This is your tweet from November 5th. So during this trial, you're tweeting out, yes?
Yes.
And you tweet out whoever these people are. Make sure you look and listen for the defendant's firearm malfunction. And then you have a winky emoji face. Is that right?
That is correct, yes.
Okay. So this is, the 5th was yesterday?
That would have been Friday.
Oh, no. He should not have been
Friday
tweeting
at
about this at all.
7:45, and what's the winky emoji?
I believe that was in response to whoever the original poster is on there. I don't know
You don't wanna-
what the
don't
original
use
post
emojis.
was, but it was more than likely in response
After
to
you
this person's
fucking
opinion.
Tried to murder someone.
It looks
Now,
so
you-
slick.
You had
Like he's
said
trying to be slick with that tweet.
you were looking for a non-lethal way to end this interaction.
That is correct, yes.
Get your gun out and begin.
Oh,
I'm
God.
gonna use
Lunch can't get here fast
chasing
enough.
or running after a man who is running away. Correct?
That is correct.
Now, you had
Gonna
said
shoot him in the leg.
you were asked about the tattoo on your arm.
This is
They're
gonna be
doing
good.
it.
Finger's face.
You have some regrets for that.
No regrets.
No.
No regrets.
Regrets.
Jacob Marshall was with
No, he's not.
you, correct?
He was, yes.
And Jacob Marshall came to visit you in the hospital. Is that right?
Yes, he did.
And I know he's taken it down, but not before we saw it. He posted something on either Twitter or Facebook,
Oh my.
right?
Correct.
This is him regretting not mag dumping Kyle. Holy God.
Remember what?
Oh man. Get ready
Yes.
for this, guys.
You're admitting to the picture. He's not going to admit to the tweet, but the picture is with the tweet. He admitted to the picture. This is Gage's statement.
Yeah, that would be an exception to hearsay.
Yep.
Because
Artie's
it's being
statements.
offered against him. It's an admission that he made against his own interests.
And in criminal cases, complaining witnesses are distinct because they are then parties to, or that the state are advocating on behalf of. So they become parties to the suit. Complaining witness is effectively an adverse party to the defense. You had no regrets that night, right? Oh, except you regretted not mag dumping into Kyle Rittenhouse. Finger objects. He knows this, as if he's not already hollowed out and laying on the ground quivering.
So maybe we should.
Do a recess.
I assume you have more questions beyond this.
We should probably get this cleared up.
Yeah, we might as well.
Because
Let's take a break. Please
this
don't
will
talk about
All right.
bury
break.
their
I
witness.
assume your
Frankly, Your
lunch will
Honor.
be here shortly. Don't read, watch, or listen to anything out of the trial.
Still leaves them on a high point. This
so
guy
it's
is
about
just
150.
riddled.
It's a cliffhanger for the
This
jury.
is the worst nightmare scenario going into lunch after a break an hour ago for the state. So they normally I would say you want a fresh jury, but they had a fresh jury going into this cross. They had a 1 hour, they had a 15-minute break. Jury comes back, they're attentive again. You get 1 hour of cross-examination, and they went straight for the throat. Absolutely demolished Gage.
It was very streamlined. He had no extra fluff. Like, he didn't have anything extra in there that he didn't need. It just was direct, straight to the point. This has been a very effective cross. He's just like piece by piece, just completely dismantling this whole image that the prosecution just spent so much time building up with the whole do no harm, and I could never shoot someone, This has been a very effective cross.
For once, it was the prosecution that was not objecting when they could have objected. That's something that's relatively rare throughout this case, and we saw it, and maybe it's because they're so demoralized.
They look horrible.
They've also lost a lot of objections.
Let's start there.
Why is it this here?
But I believe I can ask Mr. Grosskreutz if he said it. That's not hearsay. Did you say this to Mr. Marshall?
It's an adverse party statement.
I'm not asking.
Well, go ahead. Go ahead.
Not offering it to prove the truth.
He can deny it, right? And then I can call Mr. Marshall, which he was in court. Now he's under subpoena.
Oh, he's here.
He left. He
Where
got
is he?
Oh, he's smiling. Look at him.
He got
he's so
served.
excited. He's so excited.
Got served with a subpoena, and he is gone.
Well, let's find out right now whether he's here, because if he isn't here and he's served with a subpoena to appear when?
We need a bailiff to go get him.
Yeah, not till Wednesday.
Okay.
He's going to be in our case in chief.
Okay.
So
Okay.
I believe I can.
But if we could get him today, that'd be better.
Made a statement. If that witness denied it, then I would call somebody to impeach that
Good
State,
argument.
I agree with everything, but what was being marked there was a Facebook post of Jacob Marshall. That's my objection. Jacob Marshall's Facebook post is hearsay. They can call him a testify.
he's not asking to offer the exhibit, I don't think. Not yet, anyway. He wants to ask him about the content.
That, as far as that goes, Your Honor, that's fine. I anticipated the exhibit was about to be used since it was in the process of being marked. And that's why I said, Your Honor, I'm going to be objecting on hearsay grounds. The exhibit is hearsay.
I'm going to ask him if he's in this picture, which he is. And if that's Mr. Marshall in the picture, which I
Which he
believe it
is.
I'm not going to, at this point, I'm not going to ask that the jury see it. But I'm going to ask him about the content of it. And then based on his answer, I'm going to call Mr. Marshall to testify.
And then admit it through him.
Holy shit.
Certainly the inquiring about a statement allegedly made by the witness would not hearsay.
It falls under an
There
exception.
certainly is a
Social media is weird, bro.
snake of hearsay, potential hearsay. So we have to be careful.
I'm not going to, I think it's appropriate that he acknowledges that he's in the picture. And then I'm not going to do anything else with it other than to ask him the question.
Excellent.
I'm a good boy, Your Honor. I'm a good boy.
I'm not bigger.
That's my concern.
Okay.
Look at how scared of Binger is terrified of this.
115, please.
Oh my.
We'll get it in once.
God. This is definitely coming in. There's
Oh, yeah.
there's no way you get around an adverse party statement like this. And you say, oh well, Judge, they can't do that because he's just quoting the adverse party. That is still an exception to the hearsay rule. That is the fact that it's posted with the picture. Maybe the picture is hearsay. The statement is not. The statement is an adverse party statement. It's an exception to the hearsay rule. It's clearly probative. It's clearly relevant. All of this matters. Gage testified that he had no regrets. Now you get to impeach his testimony that he had no regrets, because I believe the statement is specifically, I regret not killing Kyle Rittenhouse, or something to that effect. So, I mean, whoo.
Oh boy.
Now,
Spicy meatball.
Alita, I gotta call you out.
Okay.
Call you out.
Uh-oh. What did I do?
When I said I thought they were going to go the full day on this witness. You said I thought shorter was better. Do you stand by that statement?
Shorter is better for the prosecution. But that doesn't necessarily mean that they still have, are going to come out of this doing very well.
Yeah, this is a weird.
I don't see where they go.
I'm calling you out, but I think I agree with your overall assessment. But man, this has been surgical.
Yeah. Well, so, and for anybody that wasn't there when I said that earlier, my reason for why I think it's better for the prosecution to not do a direct examination of this particular witness all day long is because, I mean, number one, it's gonna bore the jury, and the jury can only pay attention for so long. So if they have to spend an entire day with one witness getting a particular style of examination, like doing a direct examination, basically hearing between the prosecution and this witness all day long, that's a lot. And there, at some point, there's only so much information that they can retain from one person, and at some point they start to kind of check out. So I think, and that would have given a strategic advantage, I think, to the defense, that they could come up the next day for their cross-examination while they're fresh, while the jury has, like they just got up, they had their morning coffee, they had breakfast, they're ready to sit down and pay attention. But people get very squirrely after a certain amount of time. I mean, especially in today's day and age where we have social media to occupy us, and we have, multiple, like I've got multiple screens and like 5 windows up, all at the same time. That's just like our normal daily life. But when you're sitting in the juror's seat, you have nothing. You are the definition of a captive audience, because there's nothing else to capture your attention. It's just the person that is sitting on the witness stand and the lawyer that is asking him or her questions. So yeah, but I think in this particular case, I mean, defense is doing a great job, even with that being a shorter testimony that I think kind of would help the prosecution. I don't think it makes a difference.
No, and I'm joking, of course. Your overall assessment is right. It's just the defense was prepared 100%.
Oh my God, yeah.
The prosecution, to be fair, they made a very clean direct examination. They skipped the frivolity and they went right for your medical training and all that, and then went into the meat of it. The problem was, I mean, the meat of it leaves so much on the table.
Well, here's the thing: is where are we going to go?
There's a lot of fat on that meat.
Yeah, exactly, and it's already been cooked. It's already been cooked by Sharfisi. Like, where are they going to go? This is I'm thinking here, like, how is he going to deal with? Binger cannot deal with all of this on redirect. I mean, he may be able to come in and massage 1 or 2 points, but there's so much in here that some of it you've just got to move past. It's done, it's out there, and you just move past it because it is what it is, and there's no way you can spin it. Even Littlefinger can't spin that well.
And look, Binger has been through 13 jury trials, and because he's a prosecutor, he's won most of them. Prosecutions tend to win jury trials in the majority of cases, because let's be honest, most people going through the criminal justice system have some level of guilt, so they win jury trials with relative frequency. He's done 13 of them. I don't know how many Big Boy has done, because he has been a district attorney in Kenosha quite a bit longer than Binger has. Between them, you are trained and practice or whatever at jury trial to keep a poker face. You do not want the jury looking at you and drunk. Look at their reactions. They are devastated by what's going on. They see their case on fire, harder than a Kenosha business right now. And if I'm in cross, I'm actually dropping that line. You can look at the prosecution's face. They're watching their case go up like a Kenosha business right now. That's why I'm not actually on defense. But that is what's happening. You can see it. You can see them dying in real time. They know this. They know this is their best witness. They're probably going to end their case in chief with this witness. If they have someone else, they haven't indicated it publicly. It may be on the witness list. I don't know. But they haven't indicated it publicly. There's really no one else to bring. based on the admission of the facts that Kyle definitely shot these guys.
So-
They don't have
so
to
Nick-
prove that.
Probability. This is what I want to ask you and Alita is, what do you think the probability of a directed verdict here is after they rest their case in chief?
It's climbing by the day. When people first asked about something like this, I'm like, no. I mean, come on. This is a murder trial. These are fact questions for the jury about, state of mind and all that. Now, I mean, the state's case has laid out self-defense, and to the credit of Richards and Sharafi, they have expertly laid out. With this witness, by the way, you were afraid for Kyle, weren't you?
Yeah.
And then you decided.
You, with your experience and your expertise as an EMT, you understand that hitting someone over the head with a skateboard, that puts someone at great risk, right? Oh yes. And he was the one that volunteered the term head trauma. They didn't ask for it. No one said head trauma before he did. So that was powerful.
The radio is hit. We can't
That was amazing. To the chat, and this is why this is really important. Directed verdicts are judgments as a matter of law. They're not on a jury. Juries are there to decide facts, and then the judge applies the law to the facts. If the jury determines a set of facts that leads to guilt, then the judge will apply those facts to the law and prescribe a verdict of guilty. That's how that works. When you're asking on a directed verdict, you're not asking a jury. You're asking a judge to say, this is the factual basis to support the legal conclusion that there is a reasonable doubt as to the guilt of the client. And that's all you have to do. And I say that's all you have to do. Most directed verdict motions are completely ignored. They're denied out of hand, and it's not a big deal. This case has such a poor fact pattern for the state that a directed verdict, when you say based on your training and experience, the state has called this person, the state has testified to their training and or has elicited the training and experience out of them, and then for them to go back on that and say, yeah, I was actually scared for him. You go straight to the objective reasonableness of his fear of shooting Huber. When you've got Richie McGinnis on the stand saying, well, he screamed, fuck you, and reached for the gun. You're going directly to objective reasonableness for fear of imminent death or bodily injury, or imminent death or bodily injury of the people around you. Remember, if Rosenbaum or Huber gets the gun, he's not necessarily going to shoot Kyle. He could shoot anybody. He could fire off into the crowd. Everybody becomes in danger when there's a struggle over a gun. When you have the DNA expert testifying that, yeah, he is indeed grabbing the gun in that picture. I'm the state's witness. That is a picture that is true. I'm looking at it. He's grabbing it, and our DNA evidence is inconclusive as to whether or not he grabbed it. You have another big set of reasonable doubts facts. And I think they've nailed it on all three of these people. And we could really see on at least the murder charges directed verdicts on this. I want to couch that and say I still think the judge is going to deny it, but we're above an insignificant chance at this point to see it.
Yeah.
We've moved from possibility to plausibility, which is like a giant threshold. Like it's to the point where you could go to Vegas and bet on this and you might hit.
Yes. Yeah. You're not betting on 0 or 00 anymore.
Yes.
Now you're betting on like a set of numbers.
Like even.
Yeah.
Yeah, I think one of the reasons why they might not go for a directed verdict, I would wonder would be because of the local political fallout. The judge might be concerned about something like that. It might be better for it to go to a jury of peers, because then it's a lot easier to say, look, like this was not some corrupt judge or some judge who was making rulings in favor of the defense or something like that. This was an actual jury of his peers that determined that he was acting in self-defense.
Yeah.
No,
I could also
agree.
see. I could also see this judge being the honey badger and just not giving a shit, just being like, you know what, this is it. Because if
That's
any
true,
judge
too.
is going to be it, it'll be this judge. Any judge.
It's important to note that at the time all this happened, they haven't hit this part of it yet because it's really not as important. And if they have a couple questions for him, maybe this is what they're around. Gage Groskowitz is no longer an EMT. I think someone in the chat has pointed out that his EMT registration expired in 2017, which means he is 3 years removed from being an active EMT. He did testify on the stand that he was only an EMT in an ambulance for 1 year.
Right.
And the cross-exam may be waiting to ask those questions because they're seriously the lowest. But this guy has an expired EMT registration. He has an expired concealed carry. He's acting as an EMT, and he's acting as a self-defense believer. And yet he's also testifying, and I imagine this will come up too. Although I don't know if they've got so many wins, they may be confused on what to do when they come back from lunch. But they may bring up the fact, really hammer on, you said you weren't there why are you carrying a gun? You said you would never fire the gun to harm someone because that would violate your core ethics as an EMT. Your EMT license expired before your concealed carry license, right? You know, you go ahead and I don't know how you approach this questioning specifically, this one way, and you say, you didn't actually have those standards because you're carrying a gun. Of course you plan to use it. And he did get there a little bit with, you're drawing a gun that you say you're not going to use. And you let the jury just simmer on that because there's nowhere for him to go.
Yeah.
Right.
Yeah, I mean, and he's been pausing at all the right times and letting them digest it, letting them sit on it. His pace has been great. I mean, it's been something that you can follow. That's always something that I think about. Can I follow this? Am I logically into this? Just like with an opening or a closing, you know, and it's something that, for me, looking at it, even if I was a juror, not a lawyer, I'd be able to follow this clearly. And he's just caught him in kind of lie after lie, especially with the chasing thing. Just at some point, you know, just yield on that because they've got the evidence.
Yeah, and he said I'm not chasing him. I'm not chasing him. And then he
just didn't want to use the word chase because he knows how that sounds. But I mean, there's no way he knew that there was no way that factually he could get around the fact that he was running in the same direction as Kyle Rittenhouse and after him and in the same direction. You know, it just but by trying to sort of deconstruct that and be like, well, it wasn't chasing. I just happened to be running in the same direction. You know, right. It makes him look like he's trying to get out of it. He's trying to be evasive, and it doesn't play out well in front of a jury.
And there are better ways to do it. I wasn't chasing him. I was concerned for him, so I followed as fast as I could.
Right.
Something like that.
He could have tried to add that in. He could, because it's like that, you know, there are some people that are very good on cross-examination that, I mean, obviously on cross, the attorney that is doing the cross-examination wants the witness to just say yes or no, because that helps with their rhythm. It helps them get to the next question. It helps them tell the narrative that they want to tell. And a good witness is going to be on cross-examination, is going to sort of fight them on that every once in a while and kind of try to add in more sentences, sort of lengthen things out and sort of disrupt that flow. McGinnis did a good job of that. I was going to say, on his direct examination, it feels weird, but it kind of turned into a cross-examination on direct because that's how the prosecution was treating him. But in this particular case, he totally could have said, I wasn't chasing him. I was running after him out of concern because, you know, he was one piece of this puzzle, and you know, I wanted to make sure that everyone knows okay, or something along those lines.
Guys, we have another addition. This is someone who has never been on the stream before, and I want to really welcome him. He is a Canadian attorney, but also a firearms attorney, if I'm not mistaken. He can correct me on that. Up in Kanukistan. And I'm happy to welcome to the show Runkle of the Bailey. He's also another YouTuber, and you should check out his channel. Hey, welcome to the show.
Hi. Nice to meet you.
Nice to meet you all. I'm really sorry to hear that your chat. Oh, sorry. Go ahead.
I got to turn you down a bit because I have us all turned down for the video, but you're
sure.
good. Sorry.
There we go. I gotta say, sorry. I'm sorry to see that your channel is going to get demonetized because I don't think you could play somebody getting effed that hard on a live stream. That was beautiful to watch.
Yeah, it was fantastic. I mean, it was an expert cross. That's the only way to say it. It was an expert cross.
I think that's going to show up in law school classes. You know, if you want to see how to do a cross, that was exactly what they needed to do. Just came in fast and hard. And I don't think there was any wasted questions there. I was sort of watching to see if you've got those questions where you're trying to get to the point and losing the jury. It seemed like everything he asked, he either landed a really good admission or caught him in a lie. Or got him to lie further, which was then lining up for something else. It was just, that was crisp. I liked it.
How about those admissions on the civil lawsuits? So you omitted a material.
What?
What is that?
I don't know.
That's not me.
That's not me.
Either.
I don't think that's me. I'm on a...
That's literally on the Law and Crime live stream.
They're playing like old show tunes. Like, what are we doing right now?
Holy shit! Like, are they trying?
I mean, at this point, really, what they should be playing is Sarah McLachlan for the prosecution.
They should be. Look, I've heard. We've got some prominent people. Jack Posobiec and Cat Turd are tweeting out clips of the stream and stuff like that. Actually, courtesy of Viva Fry, who tweeted it out originally. They're retweeting him. So maybe Law and Crime saw it and they're doing something about the dead air. But I don't know. Like, I'm joking. It sounds like they just, they're going to have an hour of nothing. So they want to make sure people know that the video is going, I think. But, man, whew. Sorry. That was so disruptive. I forgot where we were.
Yeah, I just don't know what to expect, like, coming off of that. Like, it's almost like we hit a high and I'm like, I don't know where we go from here, but I'm strapped in for the rest of it.
Yeah, I'm confused. He did say he only has a couple questions, but I mean, you can tell. So you tier your questions in order of importance. He got the most critical things ever out of this. I asked about the civil suit. Runkle, I was curious of your opinions on how he basically impeached the complaint section of his civil suit.
I think his civil lawyer's probably just sitting there very unhappy going, okay, well, not only did he get slaughtered in this cross-examination and, his claim is going to be undermined by all of the admissions that have been dragged out of him here. But also the suggestion here that's been made that I don't think he's going to be able to escape is that this is, that he's tailoring his evidence for profit. That's going to be what's with the jury. And when he gets to his civil suit, he's going to have a real hard time escaping this notion of, listen, you were willing to tell all sorts of, false statements. And there's how much money on the line? What are you willing to do for $1?
And when you submit a complaint, that complaint is effectively under oath. Now, you get some privilege to kind of tweak your story to your own benefit, but omitting a material fact in that complaint of I had a gun and was running towards him. I mean, you're talking. So his civil suits are blaming the city of Kenosha for a failure of the duty to protect, which is a long shot suit already. And if the city of Kenosha is smart, they will not settle with this guy. But
now,
right. Now after today's testimony.
He had a chance before, and I would say even politically, perhaps, depending on the climate. I know certain jurisdictions, because I work with a lot of governments that just settle it quietly and make it go away. Right? It's a political issue. They settle it quietly, make it go away. Right? There's certain thresholds. The insurance will pay it out. It's totally settle it, let it go away. But now, I mean, they can't because it's out there. It's out there that it's a BS complaint. So now, if they settle it, the political fallback will be on Kenosha. So they have impetus to not settle it.
It's out there under oath and recorded and one of the most broadcasted trials of recent memory. I mean, Chauvin was a highly publicized trial. This is a highly publicized. I mean, for reference, by the way, shout out to the chat. We've got over 19,000 people watching on my channel, which is which is, I've worked hard on it, but it is still a humble channel. And we're not talking that this is Crowder or Shapiro or something streaming this. This is just little old me. We've got 19,000 people out there watching. That should tell you how many people are actually watching this trial. It is a very big deal right now.
There's a lot of interest on this.
I think at this point he'll be lucky if he even gets a nuisance offer. Even just like the standard, here's $1,000, go away. I don't think they're even going to do that just for the optics of it. I think they're just going to say, listen, you get nothing, go away. Thanks for coming out.
Yeah.
Thanks for playing.
Yeah.
Yeah. And
enjoy the fabulous prizes you won at this particular event.
And really, here's the other thing that they'll say in that offer. And if you proceed in this course of actions, we'll introduce his statements under oath and show the judge in the federal case that he omitted material facts. We'll ask to dismiss under Iqbal versus Twombly or Iqbal and Twombly, and we'll then move for sanctions.
Mm-hmm.
So
otherwise known as Quickball.
Yeah. Yeah. Just so you know, I mean, we will, if you go on, you can, but we will move for sanctions for misrepresentations to the court. And if you want to ask how that's going, ask Sidney Powell. Things did not work out well when your complaint involves misrepresentations of material fact. These are not minor mistakes. You had a gun, it's on video, and you omitted that.
Right. And that's the thing too, is that in a case where there's so much video and so many photos, it's like you have to know that that's going to come out at trial. You have to know it's going to be used. So you would think that they would play it much more safely than that.
Unless you're moving for a media strong arm push.
Yes. And look, they knew, like I was saying, they knew as soon as he brought up that footage. I had the footage the entire time. You knew there was something, and then you knew he was calling it. He like called it what name did he call it?
Boogaloo Boys.
Boogaloo Boys called him a stooge. Yeah, he was already in that attacking Kyle verbally before the incident even happened, right? So you knew there was stuff like that in the video. It's inevitable, right? These people get worked up. They're the ones who are the agitators, and that's the whole narrative that we've been lied to by the mainstream media. We've been gaslit throughout this, that it was the Boogaloo Boys and the far right that have been going crazy and pushing this. But you see the people that are trying to escalate it, and it's the Rosenbaums of the world, right? It's not the Kyle Rittenhouse.
Exactly, and they excellently managed that. So you said this about him, right? At that point, you hadn't seen him threaten anyone, you hadn't seen him confront anyone, you hadn't seen him do anything. He hadn't raised his gun, he hadn't raised his voice. Like, no. It's like, and it just tells the jury, this guy was immediately hostile to this person, and he has no credibility on these issues.
Yeah, and that's actually something that I just thought of as you were talking, is the fact that he initially was trying to struggle against Sheriff Easy. That he was trying to fight him on, especially on the word chase. That was one thing that he really did not want to admit to. But then over time, it's like you could see that he kind of just like whipped him into submission. That he was just like, yep, that's what it was. Yep, do you see my gun pointed at him? Yep, you see the pink mist coming from my arm as my gun is pointed at him. Whereas he had an opportunity to actually kind of say, well, from that angle, it kind of looks like it, but actually it was, to the right. I didn't have it pointed directly at him. He could have tried to fight on that, but he was already like whipped into submission and just saying, he kind of just gave up. He realized that the goose was cooked.
And that's important to breaking up the flow. That's why we talk about objecting to break up the flow, because there's a human lizard brain thing. When we start saying yes, we are more likely to say yes, right? So you get somebody saying yes. They're just going to keep saying yes, right? And he ended up saying yes, and it screwed his entire case over.
And what you're talking about there is we commented trying to be as fair as possible. Binger needs to be objecting to some of these questions. He's
ones asking about his conversations with his attorney. I was surprised that he didn't object to those.
Yeah, these are clearly privileged conversations, and the funny thing is, the way that privilege works, you can actually forfeit it forever based on any conversation around those issues. So we know that he's been talking about civil issues. It seems like his refusal to provide information was in consideration of a potential civil suit. And now he may have, again, this is going back to what these civil lawyers on the other side of these cases are thinking. They may have opened the door to the disclosure of any text messages on the day, or any text messages or communications he had with his attorney on this day or that day, because he's effectively disclosed that they had communication specifically about this consideration, and that can defeat privilege. Now, it doesn't defeat all of the privilege ever. You know, if it's a week later, maybe not, but they can push the bounds of it.
Yeah.
But does it defeat white privilege, Nick?
Nothing defeats white privilege.
My take on this witness is that he's one of these guys who thinks he's smarter than he is and really feels that that's important, that people see that. And so what he's running into is a lawyer who's really well prepared and is not letting him get away with any of these lies and is embarrassing him each time. And so once he's been embarrassed like that a few times, he doesn't want that to happen again. And so he knows he can't lie anymore or he's going to get humiliated. And at this point, he's just getting steamrolled. And it's a beautiful thing to watch when you see that, you know, the defense lawyers managed to put him in that box. And it's right where he needs him to be.
Yeah. The Law and Crime coverage of this just ended. They're going to start a new live stream. I hate that they do that. Just leave it running. But maybe they're smarter than I am. And so they cut them down into segments. I do not. We run the duration.
The full marathon.
We're doing it live.
Doing it live. No, it's so today I expected to not again, the way Binger has been conducting this case, the way he has been dragging out witnesses that are basically irrelevant. I mean, he had Corey Washington on the stand for something like 3 to 4 hours. When you really get down to it, he had Corey Washington, who had almost nothing relevant to say, on the stand for I think it was 3, and it may have been 4 hours. He had Gage Grosskreutz on the stand for 2 hours. This is their star witness. And I know they wanted to focus in on it, but based on how their trial has been going, I expected a drawn-out, several-hour testimony. I didn't think we would even get to cross today with objections and other things. I thought they would inflate it out and just give the jury their entire first day of red meat for the state. That was my thought on it. They didn't do it. But so I expected kind of a hard day for the defense, where they're fighting an uphill battle of the state's narrative. Turns out the state has gifted them pre-lunchtime of victory. They're going to come back from lunch. They're going to continue cross-examining this guy. Someone brought up that there may actually be another state witness. They may, and we may not hear it, they may recall the FBI agent back into the courtroom because now they suddenly have the mystery HD footage that they definitely had deleted. So we may actually see that guy come in to add that HD footage to the record.
I think, cynically speaking, your approach is a much better one because this witness has so many bad things about them. It would almost be better to just drag him out until the jury is just tired of hearing him. Like, do a full day and a half of just this guy until they're so bored of his existence that you might mute across just because they're like, we don't care what he has to say anymore. He's at the end of the day, he's just toxic.
And let the jury forget that the guy said that he said these specific things the day before. If
so
they
it's
would
not half an hour ago,
right? If they would have known, and they should have known, because again, we got to go back to the beginning of this. This case is built on bad facts and a legal uphill battle for the state. They've got bad facts and they've got bad laws. So all they've got is pound emotions, pound the table, so to speak. Make a big show. That's why they brought in Corey Washington. That's why they brought in all of the cops that they brought in. That's why they brought in a DNA expert who's not necessary for any factual statement on the record. They
actually ended up helping. She actually ended up helping.
They want the bloat. They want the bloat. That's what they've been going for. So, if you're going to have a guy, Gage, you have to know Gage is going to be a disaster on stand. If anything goes wrong with, like, maybe in a perfect world, he's great. And his opening probably 30, 40 minutes of testimony is very good about him being a medic and all of that stuff. He looks very, he looks a little manic, but he looks professional. He's calm and collected about his experience. He's able to recall it very quickly. So he's doing well, and he's humanizing with the jury at first. He's doing this number, and it looks okay. Once he gets to cross, you have to know if anything goes wrong, this guy's going to break apart. This is a revolutionary. This is someone who has spoken. How many communist rallies have you guys spoken at this month? I mean, on a scale of 1 to 10,
negative 20.
Like, are we on May Day level here? Like, where are we at? You know, like.
No.
You know this guy is reactionary. Hell, how many? And if you guys don't want to answer this, I'll answer first. My answer is 0. How many rallies and protests have you ever attended in your entire life?
I mean, I don't really know, to be fair, because my parents took me to a lot of bring down the Soviet Union protests when I was a kid, so...
That makes a little more sense. Those are based in red-pilled Iron Curtain.
Ban the Soviets from the LA Olympics. Actually, no, that was, I think, before I was born. Anyway, but, those kinds of protests.
Yeah, if you count going to church when I was a kid as literally a rally, because it's obviously the cause. But other than that, I've never been to a political.
Yeah, Runkle, you any?
I think there was something around firearm issues that I attended. Not a whole lot of protests. I mean,
right. So again, you've got someone who is willing to not only attend a protest at night after 2 nights of looting and burning. No, and he's already testified that he came from the Milwaukee George Floyd protests, which involved looting, burning, an injured police officer by gunfire. I mean, these are not like peaceful, white bread American people running around like, oh, I go to the grocery store, I pick my kids up from their soccer practice, and then I go protest police violence with fire and Antifa masks. That's not your average experience. And so you have to know as a prosecutor, you got this guy on stand, he is a hot button. He's a reactionary. He is an outrage pornographer in his own right. Like, and that's fine, but that's who you've got on the stand. If he breaks down, if he gets emotional, your whole case could go up, and that's what happened. That's exactly what happened.
You're kind of using his own ego and his own beliefs against him, right? Because the whole thing with the head trauma, like, it's playing into the EMT thing, right? He's asserted himself as a bit of an expert there, so he's like, I've got to show my expertise. I'm going to talk about head trauma, and he seems like a guy who's like, oh, well, I stand for my beliefs. So yeah, I'll admit I went to a rally, and I said, long live the revolution, or whatever the hell Tommy.
I'm not a member, but I am affiliated.
Yes. I'm a card-carrying member, but I only go on Tuesdays.
I can't believe he said he was affiliated. Why would you say you're not a member? You're affiliated, though. Nah, no, not really. I was
asked to speak at a thing, and I did, and that was the one time I did it, and I'll never do it again. I don't know.
Yeah, you could say literally anything. No, I mean, I spoke at a thing. If you're speaking in court, are you affiliated with the state? Are you like? People speak at things that they're not affiliated with because that's how speaking engagements go. Hey, we like what you say. You want to come to our thing? Sure. You don't have to be affiliated with them. And the fact that he said affiliated, I think right after saying he wasn't a member, again, it goes right to his credibility in a way that it's just a pointless concession for the state side of it.
You can watch all these times where he's sort of trying to think his way out of things, and he's not as smart as he thinks he is. Over and over, where he comes up with this flimsy lie, and then it falls apart on him so fast. And always, like that example of him bringing up the head trauma, it's all part of that. He thinks he's super smart, and he's in a room full of people who are smarter than he is and have had nothing but time to prepare.
Yeah. Oh, and I just remembered, thank you. You reminded me of my previous monologue about why the head trauma was important. I never finished that thought, and I'll make it brief. We're talking about directed verdicts and how facts and law apply. Head trauma as a matter of law, is serious bodily injury. It meets the standard for a justification for self-defense. If you have any level of significant head trauma, because head trauma can be a permanent brain injury very easily. It can also mean death if things go just a little bit off. So if someone takes, if someone punches you in the face, typically you're not in danger of death, although you could be if you have like a glass skull sort of idea. But if someone is inflicting trauma through like a glass bottle, a baseball bat, a drinking glass, you hit someone with a drinking glass in the head, something like that, you're talking about a potential skull fracture, a brain injury, and that is self-defense justified as a matter of law. That's why that is such a critical fact that the EMT, the only certified medical expert that we've had so far, brought by the state and is a complaining witness, just admitted that, yeah, I was afraid for a traumatic head injury to Kyle Rittenhouse. You couldn't have asked for a better reason.
Right.
Other than he was literally trying to murder him. Maybe that was
Which they've literally almost gotten, that multiple people were coming after him. Even the fact that when he was resisting the chasing, he admitted that other people were chasing him and he was following them. So it's like, okay, from an outside perspective, if you were an objective person looking at this crowd, would you say that everybody looks like they're chasing? Okay, yeah, thank you. We're done here. Like, it's just,
right.
This guy, thing after thing, line after line, he doesn't realize it, but it's exactly what Ian said. He thinks he's smart, but other people are smarter than him.
Yeah, absolutely. And by the way, even if you think you're smarter than all the lawyers in the room, remember that this is what they've been paid thousands of dollars to do for the last several months. I mean, if you're following this case at all, you know that Kyle Rittenhouse has raised a $2 million bail. Free Kyle, that was first, and then I believe Free Kyle USA, Barnes, before he was disassociated with them, had reported they'd raised over $650,000 for their defense. This defense is operating on golden skates. They know they can expend any amount of time, and you have to assume that they've expended at least a good portion of it, literally just preparing to ask you a question. And the one thing that is from one of the best videos out there, it's the Rutgers University lecture of Don't Talk to the Police. The second lecturer was a police officer, and he said, I have given hundreds, if not thousands, of these types of interviews. You have never sat through one once. I'm better at it than you. And Gage Grosskreutz, he may have been on the stand for his previous conviction or whatever. He has not done as many cross-examinations or even as many interviews as Shirafisi or Richards. These guys have both been lawyers for a long time. And someone said Shirafisi used to be an ADA prior to this, which means he's done...
He seems like it.
Yeah, and which it means these guys have done this hundreds and hundreds of times, and Gage maybe has done it once. You may be smarter than them. You're not more prepared than them.
The thing I wonder is EMTs do end up sometimes as complaining witnesses. So that may have happened before. Somebody made a spin on him or something like that, and they get charged. He comes in as a witness. But he's not going to ever face this kind of cross. Because if somebody, spits on you in an ambulance ride, it's going to be like, okay, was it intentional? Was it, it's not going to be this sort of, you are the bad guy here kind of cross.
Right. Yeah, you're the medic. And someone spit on you because they're having an episode or something.
Yeah, I mean, that has to be a gentle cross just by nature, because the medic in that situation is coming off as a hero, and you're not going to be able to displace that. You can't make that person into the villain in that case. So really what you have to do is you are mistaken, right? I mean, this guy was, he's coughing, maybe some spittle landed on you, but it wasn't intentional, right? But this is just, you are here to do wrong. You're here to do ill, to cause problems. You armed yourself for that purpose, and you are a liar because everything you've told us is BS. That's a whole different kind of cross. And there's no way he's faced that before.
Yeah, and the second, his biggest mistake was saying, I would never. I don't know if it's his biggest mistake, but it's a huge one. I would never shoot someone, even in self-defense. Because All of the jury
Why
asked
do you carry
exactly
guns?
what you just asked, Runkle. Exactly. Why on earth did you have a gun? And then why did you draw it? Like, I guess maybe if
Yeah.
you're, and it's concealed. So it's not like he's open carrying as a general deterrent. I could actually see someone saying, yeah, I open carry as a general deterrent, but I don't keep my gun loaded or I don't keep the round chambered because I really don't want to end up in a situation where I shoot someone. That would go against my core beliefs. And so, you know, I just do it so that people know, hey, someone here is armed and I feel like it calms people down. You could reasonably make that claim. You've got a chambered round, you drew the gun, and you're drawing it on the person, and you're saying, oh, I would have never shot him. And they're about to really kill him on this next statement where he said, you wish you would have shot him a whole lot.
Yeah, and it's and in the interim, showing that not only did he have the gun in his hand, but he had it pointed right at him as he was getting shot himself. I
Yeah.
mean, it just right after he had this whole like emotional display about like, well, I would do that because that's my core beliefs. I mean, the jury, it's so close together. Like the jury doesn't have much time to forget what he previously said because it was very emotional, right? So how could they not have that in their head when they're seeing this image that shows exactly the opposite? It's so effective.
I might actually start taking him into whether he's ever had any gun safety courses. Because either he says no, in which case he looks maybe a little unhinged, or he says yes, and then you can say, isn't one of the important rules of gun safety that you never point a gun at something you're not about to destroy?
Right.
And so, so either are you behaving unsafely with this gun, or were you about to shoot Kyle?
Right.
And either, I mean, it's one of those sorts. I don't know if he needs to, because everything else he's got is just gold, and this might be fishing in sort of a less interesting pond. But it's one of those questions that I kind of like, because either way they answer it, they're unhappy.
Right now, Sherfisi and Richards are literally at Wonka Factory. And they say, okay, you've taken the full tour, you've seen everything. What do you want to go eat now?
Yeah.
And they're like, God, I don't know, right? Like they
But Nick, do
They
you
have
think
so much-
do you think the everlasting gobstopper is the defamation cases that are going to roll after this? All those people
That
who
was a
spread
good
those false
way to
facts.
do it.
All those people who spread those false facts. In fact, I was talking to Nate about this. The Young Turks rolled back their statement about
They
crossing
did.
state lines and made a very explicit statement about it because I think they fear those defamation lawsuits that are rolling out after Kyle is innocent.
They may have gotten a retraction demand. They may have literally gotten a retraction demand by email or by mail from whoever's going to head up the civil case. And yeah, they rolled back that. Although Anna Kasparian, in rolling back her statement, makes a subsequent false statement, which was hilarious.
I know.
That made me happy. Ian, you were about to say something?
Is that the clip where she says, listen, I didn't know that Rittenhouse was being chased by Rosenbaum?
Yes.
That just astounded me, because it's like you've been coming out there with all these like real strong takes on this, and
Yeah.
this was known from like a week after this. Like the video clips of Rittenhouse running as fast as he could were
Yeah.
out there. So coming out
Emily!
and saying I didn't know that he was running out there was just like, then why should anybody listen to any of your opinions?
Exactly. What's up, Emily Baker?
Yo, Emily.
Not much. I see Legal Bites getting like food from heaven happening over there. It's like
I
food
know.
from above.
I know it's been wine, it's been beer, it's been Oreos now.
I love
just-
all of that.
So that everyone that's watching right now, I am not some weird alcoholic. It's much later where I am right now.
I
come on
take
now.
offense.
I-
to
Come
this.
on
Heard it
I am
now.
not like
Weird
Nick
alcoholic
Rekieta, you
like
guys.
What are you talking about?
She's like, it's nighttime where I am. It's nighttime where I am.
It is.
Oh.
It is.
I've got water because I have like multiple podcast interviews to do today. And so it's a busy day, but it was lunch break, so I figured I could come in and say hello without the chat yelling at me for talking over pointless parts of testimony.
I have figured out the sweet spot on balancing the audio now that I've had time to do it not live. And you came in a little hot, but I've adjusted you down, so you're all good.
I always come in a little hot.
we all,
yeah, I knew it was
frankly,
coming.
the only one who did, well, I didn't, Legal Bites didn't because I had her pre-adjusted. Legal Mindset did, Runkle the Bailey did, you did, and it's not y'all's fault. It's how low, I have to bring our level so far down to compensate for how low the streams are.
For the video, Runkle. Do we go with Runkle or is it Mr. the Bailey? Like what? What?
Well, it's
What
a
works best
reference
for you?
to the old, British BBC series. So just Runkle works. It's,
Nice to meet you.
nice to meet you. I've watched your channel. I subscribed, so
Thank
lots
you.
of people here that I've sort of seen faces, and nice to actually sort of put a voice to and have a chat with.
It's nice
Yeah.
to get to have a chat. It's been a very busy, like, Astro World kind of a 24 hours
my
in
God.
my world, because my coverage is mostly pop culture and kind of news of the moment. And while this is news of the moment, it's not as immediate as the stuff that I know.
As
It's
the
a very busy
15
week.
dead at Astro World, is it 15?
I saw 8, but the numbers could have changed today. There were still numerous in critical care. 17 went to the hospital, 11 in cardiac distress. In my wanderings as a human, I actually worked as an EMT for a little bit. My husband's a doctor, so it's interesting looking at both the medical stuff coming out, the liability stuff coming out. Attorney Tom has filed the first lawsuit with his firm.
Yeah, I saw that.
And another firm that I don't know if it's his father's firm, but they both have the last name Kirker. I don't know how common that last name is. So they are filed the first lawsuit, and I think had a TRO hearing today. And I'm now seeing reports that all the deconstruction and the breakdown at Astroworld has stopped, and that's what they were asking for in their TRO. So I'm guessing that the TRO was granted this morning, and all the surveillance video and stuff's going to be turned over.
So have you had any time to follow what's going on today?
I saw what you posted on Twitter. It seemed like Boom Goes the Dynamite on cross-examination is what happened today.
No,
It
yes.
was it was a 1-hour masterclass. So here's what happened.
The
Today's
defense
gauge-
just wanted to start slow. They were pacing themselves. They're like, go ahead and underestimate us. We're going to sit back for a day and let you all think we're bumbling. Get comfortable, because then we're going to come in and smash you later on in trial.
They were hunting dick.
That is what it
Yeah.
seems.
Yeah. So the short summary is today's Gage Grosskreutz, who seems to be the star witness for the prosecution. They opened up immediately with his medical expertise as a trained EMT. They went through that he was a concealed carry holder. They tried to mitigate the fact that he does have a prior conviction for what appears to be a misdemeanor, and I think they tried to mitigate that his concealed carry was expired at the time that he was concealed carrying.
I
I'll
mean,
bring in a
everyone was Kenosha shooting, so we knew that.
Everybody was connected.
One more, people?
This is
Oh
dangerous.
God, I gotta
Hey,
turn you
Viva.
down just a second, Viva. Sorry, I really don't want to hear you talking. There we go.
Just
Sorry
mute
about
him.
that.
Just mute him.
It's better.
No, it's all on my end. I've got us all turned down to keep the video balanced, but so I just had to level you out. But yeah, so first, he does a pretty decent direct examination. There's some spots where we're like, okay, this could be marked for cross, and then the crazy thing is they go to break. He says no further questions, and they go to break. They have a 15-minute. They come back, and the judge basically says you have 1 hour before lunch, and they spend an hour devastating the entire direct with a phenomenal crowd. I mean,
Sometimes
they go.
that's all you need.
Yep, they go straight for the throat on the whole thing, because one of the things he said is, I would never draw my gun and actually shoot someone. That goes against my core principles. I
Then
would
why do you
never.
have a concealed carry permit? Like, why bother?
Thank
Sorry,
you.
Exactly.
We've
Thank
asked the
you.
obvious questions already.
Yes.
I mean, you don't, but I'm also from LA, where getting a concealed carry involves like donating a kidney and having retina scans. But why have a concealed carry if you're not going to use it? The point of having a concealed carry is to be able to use it if need be.
Exactly.
It's like all the accused who are like, listen, I don't use heroin. I just happen to have some on me.
These aren't my pants. Maybe did he say these aren't my pants? These aren't my pants that the gun was in?
They got him to admit that he lied about that he omitted having a gun to the police. More importantly, they got him to admit lying to some interview where he said he dropped the gun. He dropped his gun at some point in the evening. He says, yeah, that was not true. And then the extra, the gravy for me was he has filed 2 civil suits, one in state court, one in federal court. And in both civil suits, he has omitted the fact that he had a gun and was advancing. And he admitted today under oath that he omitted those facts from those 2 suits.
Suits that were signed under penalty of perjury.
Well,
Yes.
that would have come out of the
Yes.
civil suit. The gravy on the gravy was when he admitted to being not a member, but rather affiliated with this whatever group that he was. So he shows up. At first, they painted him as being, the guy there to help administer first aid, which they even had me on their side at the beginning. And then it gets to the fact that he pulls out the gun. He admits that he pulled it out and only got shot when he pointed it at the guy. He lied to the cops about it. And he happens to be a member of whatever group that they were referring to. I don't know what it was.
He's not a member, but he is affiliated.
and he showed him
And
with
that
his
was the
fist
part
up
that
in the
he
air.
volunteered. He volunteered affiliation. No one asked if he was affiliated.
But he left it out of his civil, perjury's still a thing, people. It's a crime. I did a perjury trial once. It was the most fun I've ever had in court because it was a lot of, wait, show me again in the video where you fell. Because you said in your depositions that you fell on this city bus that you're suing the city for. And then it was like, well, you just didn't see it. Okay, good, let's rewind it and keep going. And then when he got handcuffed to go to custody at the end of trial and was screaming obscenities at me, I was like, I've done my job today.
He didn't want to kill him. He feared for his life, took out his gun because he was going to protect his life. It didn't get to that point, but he was not going to kill him because it's not in his, what did he say? Not his DNA, but rather his composition. It was as bad as a cross-examination as it could have possibly gone. I mean, he effectively admitted to only being shot when he was posing an imminent threat to Kyle Rittenhouse's life.
So I was only shot when I pulled out the gun and threatened the life of the person who then shot me because they shot first, just like Han Solo.
While I was also advancing, Emily, please don't leave out the part where I was.
But I wasn't chasing.
I admitted under oath that I did actually advance on him right before he shot me as well.
And he was only going to do a light mag dump. We're going to get to that when it comes back. Just a gentle mag dump.
He didn't recall if there was a bullet in the chamber. That he said that evening, I don't recall. There was a wording that he used which indicated deceit. He qualified his answer. That evening, I don't recall.
And then
he knew damn well he had a bullet in the chamber.
Well, his later testimony fully admitted to having a bullet in the chamber when he drew the gun.
And Viva made an excellent point about him coming on really good, like coming on as I am this. And it was to the point where I actually thought maybe the cross-examination was going to be something like, listen, you were also a hero here. It just was this confused scenario. But I actually think the prosecution did themselves a great disservice by letting him come on as such a hero, because it means that there's been such a fall. I think the prosecution would have done much better here if they'd actually brought out a lot of this dirt and said, listen, this witness is grimy. He's ugly. He's got all sorts of problems with it. There's all sorts of dirt on this guy. But you still got to believe what he says here, right? He's fessing up to things now. But because they come on with this guy as this halo, now it's not just, okay, he's a bad witness. That halo's turned into horns.
Well, no, and you lose faith with the jury as the prosecution because it looks like you're hiding things in your direct when so much comes out on cross. You've got to bring the good and the bad with your witnesses out on direct because it mitigates the damage of cross. Otherwise, as the government, you look like you're hiding things. And the more it looks like the prosecution's hiding things, the more they lose a jury. The jury will put up with that from a defense attorney because there's this understanding that the defense is doing their job, this is their job. But when you bring the weight of the government and then you look like you're hiding things, the jury will turn on you really fast. And that's something that seasoned prosecutors who have done lots of trials know, that you burn your witness before you burn the jury. And there's lots of witnesses who don't look great. It doesn't mean they're liars. They have the past they have. They've done the things they've done, and hey, who hasn't? And you just present it that way, and it goes much more smoothly.
And I would like to welcome to the stream my friend Mr. Ty Beard, an attorney down in Texas. I think we're officially at a retainer of lawyers at this point.
This is a fleet of lawyers, a gaggle of lawyers.
Yeah, is this a flock or a gaggle?
A quorum?
A murder of
A
lawyers.
gulag of lawyers.
How about just most people's worst nightmare? I mean, that's what this is basically. 7 lawyers in one chat room.
The billable hours on this stream alone are off the charts.
Completely.
Call it a whiskey of lawyers. Like, we just make up the name a barrel of lawyers.
A barrel of lawyers or a cask of lawyers? Because
Cask of lawyers.
That's too fancy Quebecois for us.
I'm with Viva. I'm bougie as fuck.
Ty, have you had an opportunity to follow much of this case? I mean, you're a lawyer who works. So
Yeah, that's the problem. So, I actually had a conference call canceled for the afternoon, so I thought I would check in, and then, well, one thing led to another, and here I am. It sounds like the prosecutors are doing a great job.
For the defense.
You know,
With what they've got.
I wanna be an equal-handed critic. They did start out okay. They did start out okay today, and I was like, oh, their direct is going pretty well for a while. And if the defense were sleeping, their direct would have gone really well the whole time. The defense just happened to be paying attention, taking notes, and fully prepared to come in today.
Wow.
And you know, Ty, you gasped, but on day 2 of this trial, it was not fully apparent that the defense was going to be fully prepared. Today,
Even on day 1. On day 1, that opening statement was not pretty.
Yeah, it was not a great opening statement, but
They also
man,
don't understand the power of foundation. We had those moments of like, well, foundation's a thing, I guess not in this trial, but
to my people who may not have been able to watch all day, Emily, Viva, and Ty, I don't know how much you guys have seen, but the mystery HD drone footage will be entered into evidence. The FBI happened to find it.
It just turned up.
They realized it was still in their trash bin after they deleted it.
Yeah.
They didn't
Like,
double-
oh,
they
these
didn't-
stupid
the FBI didn't
IMAX,
double
I gotta
check.
pull it out.
To give
wondering
the
how that's
prosecution credit, the story they were telling at the beginning of the day about what's his face, Grosskraut, being there as much of a medic to help as Rittenhouse. They had me, and I was a little nervous. I had never seen that angle of that witness. I never even thought of it. But then, the more it went on, it turns out he was there as a medic, maybe to administer aids to his friends, as a revolutionary who was there to take down the system, carrying a loaded bullet in the chamber, unlawful concealed carry because he didn't renew his license, and then he chased him down. When he was saying I wasn't chasing him, he was running in the other direction. I went back at one point to see, about the people who were shot. Then I decided to go back after him, pulled the weapon, and it wasn't until the guy started off as a saint, really. And then it quickly became clear that was just the veneer.
Video game gun pulling spin move that got his arm blown off, kind of thing.
I had never
And
seen
that's
the footage
the
that
fault of
close,
the
actually.
prosecution, though, because the prosecution set that up. They chose to paint him that way, knowing his
Yes.
full story. It sounds like they were well aware that this was going to be his testimony and that these were the facts. They did not do their job then in showing all of their witness, and that's on them.
They've been
is
also
that's a
playing
former
their hand the
prosecutor.
whole thing.
Intelligence, is that a thing? Is it like a good thing? I don't do criminal law if I can avoid it, so.
Yeah, you want a guy who seems educated and composed to talk to the jury and talk intelligibly, right? Which tends to come with intelligence. So I think it's helpful to establish that this is a reasonable person who's up there in front of you. You can kind of trust him, This is a person you would talk to, not a person you would avoid on the street because he sounds crazy. That blew up. Viva, how about the moment where they asked him, they said, so wait, you saw them bringing someone in for medical care, and then you heard people from the crowd screaming, don't let them treat you, and then you saw the person walking away. So did you treat them? No.
What was amazing there, and you made the quip also in real time. He knew Rittenhouse was there administering aid, and he's like, well, did you see him administer aid? No, I didn't see what happened after that, but I knew he was there to administer aid. And then you make a joke like, well, what happened afterwards? I don't know. He shot him. It really was as disastrous as it could possibly get, in part because of the way it started. It's true. I mean, then he comes off suing for $10 million, lying in his civil suit so that he has a greater chance of getting those $10 million. Comes out and prosecutes here. Will getting a conviction against Rittenhouse help you in your case? I don't know how that works. And he smirks like a little devious individual.
Yeah.
He knows damn well how that works, and that's how it works.
And Binger immediately should have objected. Objection, Your Honor, calls for a legal conclusion. And then he should have objected. Objection, Your Honor. They're asking for privileged conversations between him and his attorney. And Binger is asleep. And his wide boy co-counsel is making the most memeable faces today. There's one point where the camera pans over and he's sitting there like this, and you're
that
like,
was right.
The screenshots are on Twitter.
Was that pen
no,
guy
Nick,
who was
I
playing with
posted-
his pen last week when the judge was reaming him out? He was.
yeah,
he was
I
the
think
guy
so,
who's
yeah.
the guy who's
See
sued
the
is
reel-to-reel
attacking him like a
tapes.
tidal wave when he's sitting down.
Yeah.
This guy?
Yeah.
Yeah,
Heavyset
oh.
guy. He had a worse case of resting bitch face than.
I literally cannot learn his name.
Boy, he
Last
was-
night, Robert Gruler told me his name like 4 times, and I still can't remember because I just keep thinking
You're
him as
mentally blocked.
Angry Giant Man. That's all I got.
He froze up while the judge is talking to him, and he starts twitching that pen and going, oh, man, and he just gets that.
I just wonder
were
how
talking about
much
the
they
struggle.
talked to the prosecutors about the fact that cameras were going to be trained on them. Like, this office should have reminded their prosecutors, at least over the weekend.
No
Remember,
face.
They panned off the big guy as he had his hand, literally his head in his hand after that
Like
massive
that, yeah.
admission.
I've
And
done
but Nick,
that.
I don't know if you saw. I mean, you saw. I tweeted out that clip from the stream.
Yeah. Oh, it's great.
307,000 views already. That's the moment. It can't get any worse than that. And Binger not objecting. I do think at some point when it goes so badly, if you object, it's just going to make it look worse. So maybe silence is the best option. But
No,
At some point, the prosecutor started objecting. That's a stupid question.
I think they're going to be set for, education of a poker match. Of just learn a poker face, guys. Come on.
okay, here we go. We're back.
it's
I'm
something that really does
probably going to
matter.
duck out. I just wanted to say hi to everybody, and I'm going to continue watching with my kid who's home from school.
See you, Viva.
See you,
Thanks for
Viva.
joining.
Thank you,
Yes, sir,
Viva.
Beeps.
Peace, brother.
I got a little bit on my lunch break here, and then I got to jump back into court myself.
Yeah,
Oh,
and
real
you guys are welcome to come back, stay as you wish. Emily, have you ever had to conduct trial on camera?
I have not, and I'm very thankful for it. I almost got sentenced by a judge once for making a jury laugh with my faces, and he was not thrilled at all. I don't know how, I'll tell you that story another time, but I don't know how I would have done in trial on camera. We had, the LA County DA's office has a unit that does a lot with the high profile cases and goes through media training, and that really started with more media training after the OJ case.
Be allowed as has been discussed.
I just had my most recent hearing was on camera because only the parties and a couple of their associates were allowed in the courtroom, and everything else was by Zoom. We had, like 17 Zoom people because this is not a public thing like Rittenhouse. And so, I'm very cognizant that there's a camera on me the entire time.
Yep.
And, I mentioned this last night with Robert Gruler. Even when there's not a camera on me in court, I sit at the table, my hands folded in front of me, and my face neutral. I laugh at the judge's jokes.
You always laugh at the judge's jokes. I was always very mindful that the jury was always watching me, and I learned that in my first trial when a juror came up to me after trial and was like, "What were those shoes you were wearing on day 3?" I'm like, "Oh my God, they're paying that close of attention to what you're doing." And I learned that very early on, that the jury is paying attention and interpreting meaning into everything you're doing. And a fidgety DA looks like things aren't going well, and that perception carries a lot of weight with a jury. Like, oh, if you hear testimony and go like this, the jury's like, oh, that's super important. That mattered to them. That hurt them. Even if they didn't pick up the meaning themselves, your face gives it away.
Sometimes it's important to smile when you're getting slaughtered.
Yes,
Just for
it
that
is.
reason.
Yeah. Yeah, because you don't want them to